what we can do in relation to ensuring that we avoid elder abuse when acting on a property transaction where the vendor is represented by an enduring power of attorney. Justine, what do you think? What can you do practically to ensure that the principal whose lost capacity is protected?
Thanks, Rob. Yeah, there's a number of things that we can do to actually ensure that a conveyance is not going to go askew or that an attorney is not going to be misused. Firstly, we've got to check the authenticity of the document to make sure that the one that we're looking at is actually original, especially if we haven't prepared it. Secondly, we want to ensure that the commencement or the operation of the document has actually been enlivened. So, for example, if there are a medical certificate or something that is required in order to enact the document, it's not going to be enough just for a one-liner GP to say so-and-so is not able to do whatever it is. We need to actually go beyond that and ensure that it's been enlivened. And there's a decision of Daly, D-A-L-L-E-Y. That's an interesting judgment to have a look at as to what would be considered activation. We want to check that the powers and that the powers and the limitations of the document are actually correct to be enabling the particular transactions that's being proposed. For example, if there's no conflict powers or there's no gifting provisions, it may be that that transaction is not acceptable. We want to ensure that we're not acting for more than one client, as Riley and McPhee tells us. And also a handy tip is to ensure that the proceeds of the sale is actually going into an account in the principal's name, and if not, why not? So asking these probative questions can be really useful in the long term.
Justine, good practical advice. Thank you very much indeed.
Thank you.